SJC-12227, Commonwealth v. Gowdy Asenjo.
Ms. Carty, good morning.
Good morning. May it please the court, Emily Carty for Gowdy Asenjo. Mrs. Asenjo appeals from her convictions of 3 counts of aggravated rape. We briefed 2 issues in this case, as the court knows. I'd like to begin with the battered women syndrome issue. The first issue, the first complaint issue, is straightforward. I'm, of course, very happy to answer any questions that the court has on that issue, but the battered women syndrome may require more discussion, and it is the issue that this court took on direct appellate review. The battered women syndrome issue is actually quite simple. Mrs. Asenjo has battered women syndrome, and she wanted to present evidence of this mental impairment to the jury at her trial as basically as the basis for her duress defense. She has both a statutory right and a common law right to present this evidence.
Well, as a common law right, how is it that what she told to Dr. Ball becomes direct evidence of the abuse by the boyfriend?
Well, first, under the...
As opposed to coming in for the limited purpose of the basis of the doctor's opinion.
Right. The doctor's opinion alone would have been sufficient for her to have... for the admission of this evidence. To be a little schematic, the common law, she could have used the common law to present this evidence in a duress defense, or also on the issue of voluntariness. Were her actions voluntary in this incident? And if this would have been relevant to the element of voluntariness, right? The Commonwealth always has the burden to prove that an action is voluntary for it to be criminal. And just like a mental impairment in the context of murder, like an insanity context, the mental impairment can negate the essential element of the crime. And so too here, the battered women syndrome evidence could have negated the element of
Doesn't evidence have to, in a self-defense and in any type of mitigation type case, doesn't there have to be evidence in order for you to get that instruction, independent of what I told my my expert witness, which is inadmissible under DYS versus a juvenile?
Right. Well,
on direct, of course.
Right. The opinion, Dr. Ball's opinion here wasn't based on Mrs. Asenjo's version of the events of the incident at trial. That's a fairly significant distinction with the cases. Dr. Ball's opinion was based on the records that she reviewed, court records, other DYS records, and also prior restraining orders, and then an examination of Mrs. Asenjo herself. So it wasn't Mrs. Asenjo's statements that served as about the incident that served as the basis for Dr. Ball's opinion, and I think that is an important distinction. Dr. Ball's opinion under the common law could have come in evidence. Mrs. Asenjo under the common law, could have presented Dr. Ball's opinion on direct examination. The facts and circumstances underlying that opinion, whether or not they came in evidence, would have been up to the Commonwealth. If they wanted to put that in, they could have put that in.
Dr. Ball could have testified, "Hi, my name is Dr. Ball. Here are my qualifications. I looked at these particular records, and in my opinion, this person suffers from battered women syndrome, period."
That's right. I mean, she could have put in her opinion, the opinion that's set forth at the end of her report, that she suffers from battered women syndrome due to her impairment from these disorders. She was unable to use her own judgment during the incident, set forth in the victim's statement, not in Mrs. Asenjo's statement, and was doing so in order to placate Rivera and avoid the physical violence. She could have testified.
I thought what the judge was trying to say is that he's not saying that you can't use the battered woman defense, but you have to prove that you're battered before you get there. And the proof was lacking in this case because all there was what the defendant had told Dr. Ball. Is that your understanding of what he ruled?
Well, yeah, I mean, that is my understanding of how he said that there needed to be some other facts already in evidence sort of triggering her ability to put in this evidence that she had battered women syndrome, the expert testimony. And the statute, Chapter 223, Section 23F, simply does not require that. Neither does the common law, but the statute governing battered women syndrome and making it more available to people to use in their defense does not require
Well,
you
I
put
thought the way I read it, battered woman defense is an explanation for some of the enumerated defenses like coercion and duress and that sort of thing. And there has to be some connection of the defendant to the batterer's coercion or duress. And that's what I thought the judge was saying. I mean, you just can't put on this defense with an expert witness. You've got to have some foundation. I think that's what he was trying to say.
I think that is how he ruled, and it is incorrect. And it is incorrect because, for example, in a case where there's a murder and someone shoots someone else, we don't require the defendant to put on an insanity defense and to prove their insanity defense before presenting their expert. For example, in Commonwealth versus Anestal, that is a murder case. The defendant was permitted to put on her expert. And there it's self-defense, so it is slightly different. It is slightly different because the facts of the event themselves may.
Right.
But duress is different in the context of battered women syndrome, because in battered women syndrome, the fear of imminent violence is in the person already, and so that is the nature of the battered women syndrome defense. So
You distinguish between the statutory right and the common law right.
That's right.
And turn it to the statutory. Doesn't the statute say in a trial charge in use of force against another where an issue of duress is raised? So that implies that the issue has to be raised before the expert can testify, unlike, as you argue, the common law, where DYS versus a juvenile and Haney are going to govern the use of expert testimony.
I read that the statute to be more permissive, that where the issue of duress is asserted, that it doesn't say sufficiently raised to entitle the defendant to an instruction. It's just that she has to come in and say, this is the defense that I want to put on, and under the statute, she is entitled to put this kind of evidence on, both the opinion of the expert and, in contrast with the common law, also the underlying facts and circumstances of that expert's opinion. And
How do you get there?
by the text,
Statute.
by the text of the statute.
But the statute speaks of establishing the reasonableness of her apprehension. I understand, and that's the hurdle, at least in my mind, you have to overcome. That it's perfectly fine for an expert to say the information you had that she was in fear is reasonable because she had battered woman syndrome. But there has to be some other evidence that she was in fear in order to establish the reasonableness of that fear.
I don't know that I think that you can look to Anestal to explain exactly what the statute permits. In Anestal, this court says that, as 23F makes clear, the psychological consequences of a history of abuse are relevant to the consideration of whether the defendant was in fear of serious injury or death. And so the statute isn't just limited just to the reasonableness, but it is also of whether she was in fear or not. And that is important. The statute doesn't use reasonableness as a limitation. It is descriptive of the kind of evidence that the defendant can present, and also what it can be used for.
Now, in Anastal, the court wasn't really presented with the question of the admissibility of the battered women's syndrome opinion. It simply was already in.
That's
It was
right.
unquestioned. So we didn't really get to this issue.
You didn't. The focus of Anastal was whether or not the defendant was entitled to an instruction based on the evidence and how the court
Right,
should
but the
determine.
evidence was in, and it was uncontestedly in.
Yes, I mean, the foundation is there is not any case at the moment directly addressing the question presented in this case, except for the analogies to an insanity defense, and that we simply don't require the defendant, again, to prove their case before they present their expert. You can base your insanity defense wholly on expert testimony.
So let me go back to my first question, because I'm still confused about this. So you interpret the statute to mean that the expert can testify that the defendant is in fact battered, and to the effect of being battered. That's how you understand it.
Yes, I understand it to mean that she is battered because the statute permits her to present the facts and circumstances underlying the expert's opinion, which would mean, how she came to these conclusions, what was in those reports, which is usually reserved on cross-examination under the common law, and also the statute in express terms as well says she can present her opinion as well.
In your position is it doesn't matter what happens during the Commonwealth's case?
That's right. As long, I mean, the statutory language says she has to assert one of the enumerated defenses. And if she asserts one of those defenses, then she gets to put on this evidence. Now, whether or not this evidence is then sufficient to entitle her to an instruction, that's a different question. And this case is more about admissibility, not necessarily the sufficiency. In our opinion, it certainly would have been sufficient as well, but the statute is about admissibility, and it is about making it easier for someone to put in this evidence.
Well, if it comes in and it is not sufficient to generate a duress instruction, what bearing does it have on the trial?
Well, it has. There's still the question of voluntariness. And whether her actions were voluntary. It still comes in because it is just relevant to whether any participation she had was voluntary, and it can the presence, her suffering from battered women's syndrome, can negate that essential element. So it is relevant from the start, but the statute also gets us there easier and allows her to put in more information.
Would you say that if the evidence is admitted, that the judge would be obligated to give an instruction on the issue?
On the duress, or how to consider
Yeah.
how to consider the issue.
Right.
No, I don't think that the judge would be required to give an instruction about an affirmative defense.
You wouldn't be in here on another case? Did you promise?
I can't make that promise. But I don't think it. I mean,
What
obviously.
trial judge in the world would not give an instruction if an expert testified as to a limitation on a defendant?
Well, I would say it depends on what the expert actually testified to. If the expert testifies to something that, as a surprise and it doesn't quite complete her testimony, then yes, the judge has to look at the close of all the evidence to make sure that the jury charge is correct and reflects the evidence.
So here, so let's just say Dr. Ball testified, and she said, my opinion is that she suffers from battered women's syndrome, and that's my opinion. I reviewed a bunch of records. That's my opinion, because she can't talk about the records on direct, right?
No, but she can talk about the effects of the battered women syndrome on Mrs. Asenjo and how it affected her. She can give that opinion that she wasn't acting with using her own judgment, but in order to placate
Okay,
Rivera.
she says all those
And
things.
yes.
No questions. Doesn't, the Commonwealth does not ask, what's your opinion based on, just, that's it. You get the instruction? There's no factual basis in the case. I mean, in the sense of, you have the evidence of what your client did and said at the time. That's it.
Yes, she gets the instruction. And that's part of their prejudice. That's part of the prejudice analysis, that she gets the instruction because Asenjo acted in the context of the abuse to avoid physical violence. And
There's no evidence of any physical violence, none. In the past, in the present, whatever.
the expert's testimony is sufficient because that is evidence.
You're saying that the expert's testimony would include what she relied on in forming the opinion?
Under the statute, yes. Under the statute, the facts and circumstances underlying her opinion come into evidence on direct examination. That's what makes the statute different from the common law. So we have a common law way of admissibility and we have the statutory admissibility. And the
So
difference.
what does the Commonwealth do then if she says that Ms. Asenjo said that she was beaten 3 times? What does the Commonwealth do with that? If the evidence can come in through the expert, how do they rebut that?
Commonwealth versus Ostrander gives the Commonwealth a right to present their own expert testimony and examine the defendant as well. So the Commonwealth is not left without a remedy. The Commonwealth first can ask for a voir dire of the expert if they're concerned about what the expert is going to say. They can cross-examine the expert on the validity of underlying opinions.
I'm talking about the background fact that your client was actually battered. And that's the part that I'm having trouble with.
Well, they can also hire their own expert to look at the same materials or different materials and examine
You're not
her.
understanding me. Proof that she was actually battered is not in the expert's report. It's somewhere else. It's the it's the defendant's testimony, or it's somebody who saw something. It's a restraining order, a complaint for abuse in the district court, that sort of thing.
Right. I mean, I understand the concern, and the concern, I think, comes from the being used to the common law rule. But this is what the statute permits.
Well, the statute says evidence that the defendant is or has been, it doesn't say expert, just evidence that the defendant is or has been, and then the B is evidence by expert testimony regarding.
Right.
So,
It says
says
including the relevant facts and circumstances which form the basis for such opinion.
Right. It says either or both of this, so that she doesn't have to put in both. She could put in either. And then A is evidence that the defendant, as Justice Botsford just said, but we're looking at B, which is expert testimony regarding the common pattern of abusive relationships, and then the relevant facts and circumstances which form the basis for such opinion. So she can put in her opinion and the relevant facts and circumstances which form the basis for her opinion. Admittedly, this is an exception to the common law rule, but it is more permissive, and it is designed to allow individuals to put in more evidence than would normally be admissible under the common law rule on direct examination.
Okay, thank you.
Thank you.
Mr. O'Sullivan, good morning.
Good morning, may it please the court. David O'Sullivan for the Commonwealth. I have with me Jennifer Kirschenbaum, who is trial counsel. I'll proceed as my sister did to the...
Before you get there, I know she says that the first complaint stuff is easy and not worthy of, but maybe it's not. What is your view as to how the Commonwealth got in 4 prior consistent statements to the, as I understand it, I guess to the cousin, to the sister, to the mother, and ultimately to Detective Sanborn?
Your Honor, with respect to the first three of those, we have a complaint to Mandy, the victim's cousin. We have a complaint to her sister at the New Year's Eve party in 2012, and we have a complaint to the mother, which is not described. As to those first two, it's extremely clear from the evidence, both from the victim and from those particular witnesses, or particularly from the victim, that there was no disclosure of the defendant's culpable participation in these acts. It was a complaint that Rivera had raped her and that the defendant was there.
These are still out-of-court statements, though, right? As I understand it, these were kind of preemptive, inconsistent statements that came in?
They were inconsistent with the narrative at trial, which was the defendant who was on trial, Gaudy Asenjo, had participated culpably in these rapes, both as an aider and abettor and as a principal as to the third count.
So they were put in to impeach?
They were put in to impeach.
Impeach the complaining witness?
Impeach the Commonwealth's own witness, which we can do through Chapter 233, Section 23, and mass
Not
title
to
evidence.
enhance her credibility, which is the way it appears?
No, I mean, from the start, Your Honor, these were disclosures insofar as they did not implicate the defendant on trial that hurt the Commonwealth's case, that the Commonwealth needed to explain, and that our evidentiary law permits them to explain by eliciting them on direct examination as long as we give them an opportunity to explain the reason for doing so. And as the judge found, they were contextual and allowed the jury to understand how her complaint against the defendant, which came along much later in 2013 ultimately to the officer, came to be.
But you've got a complaining witness who's going to tell the whole story, which is going to accuse the defendant of having participated in the crime. Now, if you put on the first complaint witness as the cousin, she could have explained, the complaining witness could have explained that, well, she didn't implicate the defendant at that point because she loved her cousin, she loved her aunt so much. And all those explanations could have come in that way. You didn't need to do this, did you?
Well, the judge is granted discretion in this area to designate the person to whom the victim first disclosed.
Not unlimited discretion.
Not unlimited discretion, but the judge has to identify, in the phrase of this court, the point at which the accusation first surfaced. The accusation at issue here is not the accusation against Luis Rivera. It's the accusation against the defendant.
Seems like a complete end run around the rule.
Well, I'm not arguing the principle would have no limit.
Wonder, maybe it is time to just get rid of it altogether.
Well, I would say that this court, or this case is an illustration of the wisdom of this court's opinion in Aviez, in which it dialed back from the idea that the first complaint doctrine is a rule, and rather it's a body of governing principles that should inform a judge's decision as long as he carefully applies them in the circumstance.
That may support the view that it was within the realm for the judge to determine that the statements to Detective Sanborn were the first complaint. But the problem I have with your prior inconsistent is that she's charged not only with having raped her, she's charged with aiding and abetting Rivera in the rape, and the statements you describe are entirely consistent with the fact that, first of all, she was raped by Rivera, and secondly, that she was there and doing nothing to prevent it, which is consistent with the idea that she enabled it. So it's not, I mean, it's inconsistent in the sense that it doesn't speak to the last act of her physically raping her, but it's entirely consistent and supportive of everything else that you're trying to prove.
Well, that was not the view that the defense took of these statements at trial. In fact, they featured prominently in the defendant's attack on the victim's credibility because they were inconsistent in the key way that was at issue in this trial, was that the defendant was not merely present, was not merely associated. Obviously, neither of those would be sufficient to justify aiding and abetting liability. She was, in fact, arranged for the sexual encounter with Rivera, prepared the victim for it, called Rivera, had him come over, and then she suggested that all three of them go into the bathroom and then participated as a principal in the rape. I mean, that is vastly different, I would submit, Chief Justice Gantz, from a statement that that she was merely present there. That would not qualify, I would submit, or at least the judge acted within his discretion in ruling that that was not the point at which the accusation against the defendant first surfaced. Now, in ruling this way, the judge knew that the complaint to Mandy, which implicated only Rivera and not the defendant, was coming in anyway, because the defense counsel made clear that she was going to call Mandy in her case, if the Commonwealth did not call her, as a witness, in fact, secured funds to do so. Ultimately, she did not call her, but the judge knew, and the defense confirmed when the judge inquired of defense counsel, that this was coming in anyway. And from the opening statement, this featured prominently in the attack on the victim's credibility.
Did the judge engage in any kind of prejudice analysis before he allowed the 3 other statements to come in? Was that raised at trial by the defense?
There were extensive discussions about both the introduction and the designation of Detective Sanborn as the first complaint witness, and about the possible prejudice arising from the prior inconsistent statements. And Judge Lang brought up precisely the question that Chief Justice Gantz brings up, and noted that there was some consistency, although it was not consistent in the main way that it would need to be to qualify as a first complaint. But in the course of that prejudice analysis, the judge noted that it was essentially coming in anyway, that the defense was going to call Mandy as a witness, and she was going to testify to the prior disclosure that only implicated Rivera. And this, of course, came out in the victim's testimony, and ultimately, for reasons that seem plain to me, they didn't need Mandy because the victim candidly admitted that I didn't implicate the defendant because I didn't want to implicate her at that time. I still loved her. I didn't want to believe that this happened. But in a sense, that was coming in, and that was part of the prejudice analysis that the judge engaged in. And I would say that the judge had read all this court's cases on the topic, and engaged in a very careful analysis of this particular factual scenario in rendering his decision. And it is, of course, within his, this court has said that that judge is in the best position to determine, based on the particular facts of the case, whether the application of these principles. Now,
If you didn't have this rule at all,
Yes.
so presumably the victim is going to testify and is going to get on cross-examination questioned about she was there, the prior statements that didn't implicate the defendant, right? And then wouldn't you be able to get in what you wanted to get in?
only if there was the rule against prior consistent statements requires that they refute that there's a reason for the fabrication, and that the prior consistent statement preceded that reason. So it wouldn't necessarily come in for that reason, unless it came in the judge's discretion in rebuttal. Now,
In what way does this impeach her, though? I just don't understand that. It doesn't, I don't understand how it impeaches the complaining witness to say, well, of course, when you told your cousin you didn't say that your aunt had done these things.
well, because it leaves out
Something out, but
the major.
but she's got a real explanation for why it was left out, which is that she just loved her aunt and she didn't want to, it's not like she said her aunt didn't do it.
Correct. The defense view at trial, again, was that that these impeached her credibility. And these were statements as a result that we needed to bring out on direct examination, explain. And there is certainly a limit, and this gets back to a question that Justice Gantz was asking, to the principle that we're arguing about, the admissibility on direct examination by the Commonwealth of prior inconsistent statements with respect to the complaint. Had the initial complaint to Mandy disclosed that the defendant had participated in this act, but had not included all the acts, for example, so that she had arranged the sexual encounter with Rivera, but didn't detail that she had also participated in the rape, then we would not be able to admit those as prior consistent statements, because we would run up against the principle of the first complaint rule, which would say that we have to the extent that these are, at bottom, complaints of sexual assault against the defendant who's on trial, they're not entirely consistent with her story. She left some things out in that first complaint, but at bottom, they are at least complaints of sexual assault against the defendant on trial. We likely couldn't do that. It would approach an abuse of discretion in that different scenario to admit as prior inconsistent statements, her various complaints or various complaints in which she also implicated the defendant. But that's a very different scenario than the one Justice Lang or Judge Lang faced in this circumstance.
Doesn't a fresh complaint? I'm sorry, I'll date myself. Doesn't the first complaint doctrine take that into account? Because the instruction says, and what the reason why it comes in is we're supposed to tell the jury. It may be by what it says it omits to say, and the omits to say portion is an inconsistent statement. So by using these preemptive inconsistent statements, you've in effect put in 3 first complaints, and then a first complaint.
Not a first complaint against the defendant on trial, though.
But that's the thing. I mean, where is the law that says it's about the defendant who's on trial as opposed to the event itself?
I would say that that's implicit in
Is
the
it?
court's
I
rule.
mean, isn't it really about giving some nods to the fact that we still in this culture require somebody who alleges to have been raped that she have complained about it to someone? And she did that. She complained to someone. She complained to her cousin that she had been raped. She doesn't have to give all the details.
Correct.
We've been clear about that.
Correct.
So why isn't that what fulfills the function of first complaint?
While the complaint need not completely replicate the defendant's trial testimony, of course, and could omit details and still constitute a first complaint, at bottom, the Commonwealth submits that it must be a complaint of sexual assault against the defendant who's on trial. And I would analogize this case to the appeals court's Rivera case, in which they said the fact the defendant, prior to her complaint of a sexual assault, had alleged the defendant physically assaulted her, meant the defendant that the Commonwealth could still admit as the first complaint of sexual assault, the latter complaint.
But first complaint goes to sexual assault, does it not?
Correct.
Right.
Sexual assault by the defendant
And she said
on
that she was
trial.
sexually assaulted by the male.
Correct. And the judges, in the exercise of his discretion, said the first time she disclosed the defendant's culpable participation, to borrow the judge's phrase, in that assault, in any way, was, and not mere presence, but culpable participation in any way, was to Detective Sanborn in that second interview.
We didn't say a judge couldn't abuse his discretion in events.
True. True.
Can I turn to the statute, the 23F?
Correct. Yes, Your Honor.
So what do you say to Ms. Carty's argument that it would be okay without having her client testify or any other independent evidence of the relationship between her and the co-defendant, that the expert, Dr. Ball, could talk about the relevant facts and circumstances which form the basis for opinion? In other words, repeat what it is that the defendant told Dr. Ball.
To the extent that that portion of the statute, Your Honor, is a change in our evidentiary common law with respect to DYS via juvenile or Jaime, what it does not say, and this would also be a direct contradiction of our evidentiary common law, is that those statements may be considered for their truth. What the defendant attempts to do in this case is to conflate a pure criminal responsibility defense. And she correctly points out that in this court's Ostrander case and in the reporter's notes to Rule 14a2, you can advance a criminal responsibility defense through battered women's syndrome and PTSD. This may be done. Of course, we've evolved the Blaisdell procedures to give us, the Commonwealth, an opportunity to meet that evidence. But there is no allegation here that the defense complied with the Blaisdell procedures, that they gave a notice in compliance with Blaisdell and an opportunity.
That argued below?
It was not argued below, and it was not, there was no compliance with the Blaisdell procedures
Nor was
below.
Blaisdell argued below.
Right, the failure to comply with Blaisdell. My memory was Judge Lang never touched that, and that wasn't part of the proceedings.
It wasn't, and here's why, Justice Gaziano. The defense position below was that they wanted to advance a defense of battered women's syndrome duress under Section 23F. And that's a fundamentally different defense in the following way. While, as my sister correctly points out, there's certainly some overlap with the criminal responsibility defense. You're, after all, saying something about the defendant's subjective mental state due to her history of abuse. You're also making allegations about the external facts, the particular external circumstances, objective circumstances of the actual event in the self-defense context and in the duress context. And here you're saying that there was a present, immediate, and pending threat of such a nature as to induce a well-founded fear of death or serious bodily injury if the act was not done, and that there was no reasonable and available means of escape. To the extent that the defendant would assert that, well, this was all implicit, well, then the jury needs to hear about the objective circumstances and her subjective implicit reading of those circumstances and about the history of abuse. What the defendant may not do through, of course, our common law and through Section 23F is advance totally through an expert, through self-serving statements to an expert, assertion of about those external circumstances of the event. In that way, this is fundamentally different from a criminal responsibility defense, and I would ask the court to affirm.
Before we leave
yes.
that, and I know you're over your time, just want to make sure I understand your position. Let us imagine that she had testified, the defendant, and said, I did this because I was frightened of, he had beaten me before, I was frightened, and I did it to avoid him beating me later, all right? And then they call the expert, and the expert testifies, in my opinion, she suffers from battered women's syndrome, and the support for that is that she related to me these various events, and she goes through the entire history of their relationship and discussion of the battering events. Is that all admissible in your mind under the statute?
I would say it is. With respect to,
Is it admissible for its truth?
well, what was admissible for its truth is the victim's testimony in regard as to a history of abuse and as to the effects of that history of abuse on her opinion. What is not admissible are any additional statements the defendant may have made to
Well, you said not admissible. I mean, would it not be heard by the jury, or would it come into the jury with a limiting instruction that you may consider that only with respect to your evaluation of the opinion of the expert?
with a limiting instruction, Your Honor.
So it would come in, but it would come in with a limiting instruction.
Correct.
And it could come in on direct.
To the extent the court reads 23F that way, yes, it could come in direct, but only with that instruction that the judge made clear he was going to give.
Okay,
and the Commonwealth.
so your argument as to its inadmissibility is that there was not other evidence in the record of that.
Correct. That's correct, Your Honor. And I would just make the point that this is perhaps not clear from the brief, but the judge denied the defendant's effort to admit the battered women's duress defense solely through the expert. But the judge, in fact, allowed the defense motion to admit Dr. Carroll's testimony pending receipt of a proper evidentiary foundation for that testimony.
What was
You
the
mean
judge?
Dr. Ball?
Dr. Ball,
Yeah,
correct, I'm sorry.
What was the evidentiary foundation the judge was looking for?
Well, some evidentiary foundation that would have supported the defense of duress. Of course, the only version of events that the jury heard was the victim's version of events, in which the defendant was, in fact, the prime mover, or appeared to be the prime mover of this sexual assault.
What's odd in this circumstance, of course, is that you don't have the victim as the defendant as you did in Anistal.
Correct. Yeah.
Victim, it was in Anistal was, of course, the one who was murdered, but the victim of the battered women's syndrome in that sense. The defendant was the one. Anistal was very different factually than this case in terms of the application of the battered women's syndrome defense.
I would agree, Your Honor. I would agree in the sense also that there was a factual basis for self-defense in that case. In the Commonwealth's case, there was an inference on the Commonwealth's evidence that the defendant could have been acting in self-defense, and that's what triggered the relevance under 23F of the battered women's testimony, which, as you pointed out to my sister, was not opposed in that case.
Yeah.
Okay, thank you. and we'll take our morning break.
All right.